I will first call the meeting to order. The meeting of the Senate Judiciary Committee is called to order. And committee members should have received an email this morning about the paperless committee. And if you would still like your committee folder to have hard copies of committee documents, please make that request known to the committee assistant. So I'll then make a request for any bill introductions. I don't see any bill introductions, so then we can move right into our hearing on Senate Bill 4 and open the hearing on Senate Bill 4. If we could first have the reviser give us a little bit of a bill brief.
Thank you, Madam Chair. Good morning, committee. This is Jason Thompson with the Reviser of Statutes. Senate Bill 4 changes the criminal penalty for unlawfully tampering with electronic monitoring equipment. Current law in KSA 21-6322 sets the penalty for the crime at a severity level 6 non-person felony. The bill would change unlawful tampering in the case of electronic monitoring equipment used for supervision of a felony offense to a severity level 8 non-person felony, and unlawful tampering in the case of monitoring equipment used for supervision of a misdemeanor or a civil case to a Class A non-person misdemeanor. So it goes from a flat level 6 under current law to either a level 8 or a Class A misdemeanor, depending on why you're on the electronic monitoring equipment. I'll stand for questions.
Thank you, Jason. Does any committee member have a question for the reviser? Yes, Senator Corson.
Madam Chair, can you just explain in terms of penalties, potential penalties that sort of like in months or whatever the penalty would be, how this would increase it?
Yes, Madam Chair, this is Jason again. I will pull up the sentencing grid. I think we have one handy from yesterday. Just want to give you the right ranges here. Okay, so on a severity level 6, the current law, you have a range on the low end criminal history I from 17 to 19 months up to, on criminal history A, 40 to 46 months. And then if you go to a level 8, which is the proposal for violation of monitoring equipment, tampering with your electronic monitoring equipment, if you have committed a felony and that's why you're being monitored, that would be 11 to 13 months on criminal history I and 30 to 34 months on criminal history A. I'm sorry, I read the wrong line. 7 to 9 months on criminal history 9, level I, and 19 to 23 months on criminal history A. So you're looking at a difference of potentially 19 down to 9 on the low end and 46 down to 23 on the high end. And then for an A misdemeanor, the penalty is up to a year in jail rather than prison. So the substantial difference there between a level 6 felony and an A misdemeanor.
Any other questions for the reviser from the committee? Seeing none, then we will have our first proponent oral conferee, Scott Schultz from the Kansas Sentencing Commission, who is joining us by WebEx. Please introduce yourself and welcome back to committee.
Good morning, Madam Chair, members of the committee. Scott Schultz, Executive Director with the Sentencing Commission. Thank you to the chair for having this hearing today. This comes to you from the Joint Corrections and Juvenile Justice Oversight Committee. That this is one of the several bills that were pre-filed. It is also a recommendation of the Sentencing Commission. It is also a recommendation of the Kansas Criminal Justice Reform Commission that has met for the last 2 years and did include it in their preliminary report last year, and the final report to the 2021 legislature this year. So this is what is normally called a proportionality bill. Part of the Sentencing Commission's job, as well as the Reforms Commission's job, is to look through and determine what crimes may not be as proportional as other crimes. Many of us, as many of you know, our legislation in the criminal justice space takes place many times, or most times, on a piecemeal basis. And so going back and looking over it in mass to see where we could potentially tweak things a little bit is essentially what this bill is. And so the charge of the Reform Commission, as well as the Sentencing Commission, was to look at proportionality. And so this particular crime, the unlawful tampering with an electronic monitoring device, normally what you would normally associate with would be one of the electronic monitoring bans that would be placed on an offender if they were placed on bond, for example, or they were on supervision for probation and they had an ankle bracelet, that type of thing. This would be if you were tampering with that, such as cutting it off and fleeing the area or something of that nature, so you couldn't be tracked or monitored. So we looked at this. This is the same bill as House Bill 2027. It was passed out by House Corrections yesterday. The current crime is a severity level 6 offense, and we're concerned with that just simply because having an ankle monitor that you cut off, which is we've heard testimony a couple of years ago that it's about a $28 item, is essentially similar to being convicted of aggravated battery, aggravated assault, indecent solicitation of a child, which, those are obviously normally crimes that are associated with greater harm to the community. So placing this down in a setting in which we have two-tiered, one for felonies and one for misdemeanors, is something that we support, and we would ask this committee to support. So if, for example, I'm on supervision for a felony and I cut off that bracelet, I am then subject to a level 8 non-person felony. If I am on supervision for a misdemeanor theft, for example, and I cut my monitor off, I'm actually subject then to a Class A misdemeanor. It is currently possible, and this is again where the proportionality comes in, that I could be on supervision or out on bond for a misdemeanor theft, and if I cut off my band, I would now be subject to a level 6 felony, which obviously is more severe than the shoplifting charge that I'm actually out on. So doesn't make a whole lot of sense, and that's why we're bringing it to you. Similarly, even in the felony ranks, if I'm on supervision for a burglary or a felony theft, this particular, right now as the law stands, I would be charged with a level 6, which is even higher than the burglary and the theft for this particular offense. One of the concerns is that you're not you're not being compliant, so we should have penalties for that, and certainly this does do that. But also keep in mind that we do have special sentencing rules for folks that are out on bond or on probation or even post-release supervision after they get done in prison, so that if they would actually violate that, they're subject to potentially consecutive sentences or presumptive probation in a situation where they would ordinarily get probation. So the law already actually covers those folks that are currently on supervision and they violate that. Again, if you look at the bed space impact that our office has submitted to you, 9 or 10 beds is the bed savings. But for basically all these reasons, again, it's a proportionality circumstance in which having these two tiers certainly makes a lot more sense than the egregious amount of a level 6. And so for those reasons, I would stand for questions at the appropriate time, Madam Chair.
Mr. Schultz. Committee, also in your committee documents for today, we have written proponent testimony from Jennifer Roth, Kansas Association of Criminal Defense Lawyers. And do we have any questions from the committee for proponent, Mr. Schultz? Seeing none, I will then move to oral testimony from our neutral conferee, Ed Klump, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers Association. I believe Mr. Klump is appearing by WebEx. Mr. Klump,
I am.
if you'll introduce yourself and welcome to committee.
Thank you. My name is Ed Klump, and I do represent the 3 associations the chair mentioned. And we are here today in a neutral position on Senate Bill 4. We also testified in the same position on House Bill 2027, which Scott referenced a few minutes ago. Our associations have opposed bills similar to this in the past. We shifted down a little bit to neutral this time because of the proportionality considerations, and that those considerations were made by both the Sentencing Commission and by the Kansas Criminal Justice Reform Commission. As we look at this bill, we would ask you to consider a couple of things. First, on the grid, which Jason explained, one of the things that concerns us when you drop from a 6 to an 8 is all of the boxes that change from a presumptive imprisonment to a presumptive probation in the C, D, E, and F categories. So you wouldn't reach it at let me get this straight here. I guess I need to rethink that a little bit here. We're at a 6 now. It's going to an 8. So from a 6 to an 8, you drop down into that presumptive probation boxes more. So that's concerning to us. But the main thing we want you to think about is, why would a person cut a device off? What is their motivation for doing that? And our concern is that when they're cutting a device off, they're doing it because they want to go out and do something that they're not supposed to be doing as a condition of their release. And many times that is committing other crimes or other concerning activity. We understand proportionality. We believe proportionality is important. I personally have some experience with that when I was on a Criminal Code Recodification Commission. I served on a committee of a handful of members of that commission and a handful of members of the Sentencing Commission, and we put together a comprehensive proportionality package, which didn't go anywhere. It's a very hard pill to swallow when you try to do it all in one bite. And we believe the methodology of looking at these as bills come up to change statutes is probably the appropriate time to do that. So one of our things that we're really concerned about is in this misdemeanor area when it comes to the crimes surrounding domestic violence and crimes like that. And so we would ask you to consider an amendment that I outline in our testimony there, that in those, when the monitoring device is in place because of a misdemeanor crime of interfering with parental custody, criminal restraint, domestic battery, stalking, or intimidation of witness or victim, or protection orders, that remain a felony and not be moved to a misdemeanor level. Those are the crimes where we see a lot of activity between offenders that are on release and the victims and the witnesses to those crimes. And we would ask you to consider making that amendment. That amendment was made in the House to House Bill 2027 prior to passing it out yesterday. And I believe with that, Madam Chair, I'll stand for questions.
Klump. Do we have any other conferees, proponent conferees in the room or on WebEx? Seeing and hearing none. Do we have any opponent conferees, either in the committee meeting room or on WebEx? Seeing and hearing none. And do we have any other neutral conferees, either in the committee meeting room or on WebEx? Seeing and hearing none, then we will take committee member questions for Mr. Ed Klump. We have Senator Bowers. Go ahead.
Thank you, Madam Chair. Ed, is this common? Is this a common problem that we need to address? Is it are more people taking it off now that we're looking at it? Or I haven't heard this one before, so I'm just curious. Thank you.
I really don't have the data on the number of these cases where it's cut off, but certainly the cases that we're talking about in the amendment are cases that are very common, where we have offenders who are going back and trying to recontact victims and witnesses, especially in domestic cases. But I can't answer the one on the number of cases where they get cut off. I don't know if Scott has that data or not.
Madam Chair, I can respond to that if you would like me to.
Sure, go ahead. Please introduce yourself.
Scott Schultz with the Sentencing Commission. I'm going to go ahead and share my screen. I hope you can see this. In the Sentencing Commission's impact, Senator Bowers, you can see that we've had, for example, in fiscal year 19, we had 46 offenders that were convicted of this crime. And this is kind of the breakdown then as far as where they were sentenced at. Why they were sentenced at level 8s, those were probably attempts that they pled to instead of being convicted of the primary crime of that is a level 6. So that kind of gives you an idea of that there are folks that are actually being at least 18 of them anyway that were sentenced to prison last year because of this.
Any other questions? Senator Wilborn.
Thank you, Madam Chair. This question is for Scott Schultz. Just to confirm what I think, I believe this was a recommendation from the Criminal Justice Reform Commission and was in the form of a House bill last year that passed the House pretty wide margins, and the COVID curtain was pulled. Am I correct about that statement?
Madam Chairman and Mr. Vice Chair, yes, that would be correct.
Thank you.
Any other questions, committee? All right, seeing none. Oh, excuse me, Senator Gossage.
Seeing that the amendment has been added on the House side, how comfortable would you feel with adding the amendment on the Senate side?
Mr. Klump?
Actually, I think this is for Mr. Schultz.
Scott Schultz with the Sentencing Commission. That's something that the House Corrections added on. Those are things that if it was between not getting this through and adding that amendment, I don't think the Commission would have any problems with adding that to adding that amendment on.
Thank you.
Any other questions from the committee? Seeing none, then we will close the hearing on Senate Bill 4, and we will, committee, we will open the hearing on Senate Bill 5. Mr. Revisor Jason, if you could give us a bill brief on that.
Yes, thank you again, Madam Chair. Jason Thompson with the Revisor's Office. You should all have the bill brief for Senate Bill 5, and for many of you, this will be deja vu. I think we've seen this one a few times over the last few years. Senate Bill 5 raises the felony loss threshold for certain property crimes. Current law sets the felony loss threshold for theft of property lost, mislaid, or delivered by mistake, a crime of criminal damage to property, a crime of giving a worthless check, counterfeiting, criminal use of a financial card, impairing a security interest, Medicaid fraud, official misconduct, presenting a false claim, misuse of public funds, and lastly, the crime of criminal desecration at $1,000. The bill would simply raise the felony loss threshold where you go from a misdemeanor to a felony to $1,500. And I'll stand for questions.
Thank you, Jason. Does the committee have any questions for the reviser? Senator Thompson.
Thank you, Madam Chair. Thank you, Jason. What was the impetus for this change? Just curious.
Jason?
Thank you again, Madam Chair. Jason Thompson again. Our proponents can speak to this more thoroughly, but the very brief note is that in 2016, the felony loss threshold for the crime of theft was raised to $1,500 from $1,000. And pretty much ever since, we've been looking at whether these other crimes should have that same threshold or a different threshold. And now you've been brought this bill on behalf of the commission and both the Sentencing Commission and the Criminal Justice Reform Commission, recommending that those thresholds be leveled to $1,500 rather than $1,000.
Thank you. Thank you very much.
Other questions? I have one question, Mr. Thompson. Could you tell the committee a little bit, you said this may be deja vu, a little bit of the history of this bill, if it had passed either chamber before?
Madam Chair, I don't have the full, Jason Thompson again. I don't have the full history in front of me, but I do know last year the bill passed the House, did not pass the Senate. I believe that's happened at least one other time. I think our proponents may have a better history of it, but I don't believe it's ever passed the Senate. I know it's passed the House before.
Thank you, Mr. Thompson. With that, then, we will invite Scott Schultz from the Kansas Sentencing Commission to provide testimony. Mr. Schultz.
Madam Chair, members of the committee, Scott Schultz again, Executive Director with the Sentencing Commission. This again is a proportionality bill, and to kind of speak to some of the historical aspects, part of the issue back in 2016, the commission again was looking at proportionality. Since that time, of course, the Reform Commission has come alongside and endorsed this as well. This is also was pre-filed by Joint Corrections and Juvenile Justice Oversight, and so this is this same bill was actually passed out of House Corrections yesterday. The part of the going back to the history, as time has gone on, you know, a dollar is worth less and less as we progress as far as time is concerned. And so for theft, for example, we did used to have a felony theft threshold of $500, and that was actually changed in 2004. It then again was adjusted in 2016 to $1,000. What happened then was an inquiry was made, what about the rest of these property offenses? Why are we not increasing those from 1,000 to 15 as well? And so that has been the purpose then of saying, you know, why is theft $1,500 and all the rest of these property crimes are $1,000 thresholds? Why is the Attorney General's office pushed for increasing the penalty for mistreatment of a dependent adult in 2018 that was passed as well? So now we have those two crimes that have 1,500 thresholds, and the rest are still at 1,000. So what you're being asked today, and we'd ask you to support it, is those other 11 crimes that are property offenses, many of which don't even actually receive a whole lot of convictions, would then be, that threshold would be raised from 1,000 to 1,500. If you look at the impact that the Sentencing Commission has actually submitted to you, and I hope you can see this one. Again, We can look at the scope as far as the number of offenders, 125 offenders within the 11 crimes that is being proposed to actually be changed. And so in many cases, there's very few of them on a yearly basis that are actually used. Nonetheless, those, there is, again, a proportionality issue that the Reform Commission found relevant, as well as the Sentencing Commission. So how many of these then, if you want to look at the range, this bullet point below the table then kind of gives you an idea as well as to what was that restitution range of those property crimes, anywhere from $361 to $186,000. And 4 of them were actually less than 1,500, 2 less than 1,000. So again, we're talking about a few that that are going to be applicable here. However, again, it becomes a proportionality situation. So what I've done is any concerns that you would have as far as well, increasing the penalties is going to cause everybody to go out and commit these crimes because now they'll be misdemeanors rather than felonies. The information that I put in my testimony as far as the Pew Charitable Trust had done a survey of 28 states, which included Kansas back in 2016, and they studied those that had actually raised their felony theft thresholds and to see what kind of impact that they had had. Their findings revealed that raising those thresholds has no impact on the overall property crime, and I even attached the Kansas graphic in there for you. Also, that the folks that or the states that increased their thresholds higher had the same average decrease in crime as the 22 states that didn't. So no effect there. And then finally, the value of these states' felony thresholds, whether they were 500,000 or 500,000, 5,000, 1,000, or $2,000, had no correlation with the rate of property crimes. So one of the other points that I wanted to make, and I'll close here real quickly, certainly if some of these become misdemeanors, that still gives the court an opportunity to sentence them to jail. And in some cases, it actually would be a bigger hammer than if they were convicted of a low-level felony. So they have the opportunity of potentially up to a year in jail, depending on the crime. Again, from the offender side, having a felony conviction, obviously a stigma is placed on those individuals. And again, we're talking about property crimes here, not person crimes. These are all property crimes. That stigma that would attach in terms of being able to gain employment, housing, being able to vote, possessing a firearm, those type of collateral consequences. And finally, as I've indicated, there is a small bed savings. So we ask you to support this particular provision. Again, it's a recycle, but we'd ask that now that hopefully we have an entire session to consider these things, we'd ask you to support it and pass it out favorably. And with that, I'd stand for questions at the appropriate time.
Schultz Committee, in your committee documents, you also have written proponent testimony from Jessica Glendenning, Kansas Association of Criminal Defense Lawyers. And do we have any other proponent conferees in the committee room or on WebEx? Hearing and seeing none, we will open it up for questions from the committee. Seeing none, then, do we have any opponent conferees in the committee meeting room or on WebEx? Do we have any neutral conferees either in the committee meeting room or on WebEx? Seeing none of either of those, we will then close the hearing on Senate Bill 5. And committee, then, we will turn to, I want to also point out that in your committee documents, you have fiscal notes for the Senate bills that we are hearing today. We'll then open the hearing on Senate Bill 6 and ask Mr. Thompson of the Revisor's Office to give us a bill brief.
Thank you again, Madam Chair. Jason Thompson with the Revisor. Senate Bill 6 would count any crime with a domestic violence designation as a prior conviction under domestic battery. So current law in the KSA 215414 provides that domestic battery is a Class B person misdemeanor, a Class A person misdemeanor on a second conviction in the immediately preceding 5 years, and a non-grid person felony on a third or subsequent conviction in the immediately preceding 5 years. Current law also requires those prior convictions to be for domestic battery. But this bill would count any criminal offense that includes the domestic violence designation as a prior conviction for purposes of our escalating penalty. That domestic violence designation, sometimes called the DV tag, is found in KSA 22-4616, and that was enacted in 2010 or so. And it allows in all criminal cases that are in the district court, if there's evidence that a defendant committed a domestic violence offense, they can then determine whether that happened and tag the case with a DV designation, a domestic violence designation. So if that case has been tagged, it can now, under this bill, be used as a prior conviction for purposes of domestic battery and increase your penalties. And I'll stand for questions.
Thank you, Mr. Thompson. Committee, any questions for the Revisor? I have one. Do we have any history of whether this bill or a similar one like it has passed either chamber or been heard before?
Thank you again, Madam Chair. Jason Thompson. I have a note that 2020 House Bill 2518 was this bill, and I believe that passed the House, and that's why it's been requested again on behalf of the proponents, and hopefully they'll speak to it a little bit more.
Thank you, Mr. Thompson. Committee, then we will invite our proponent. Actually, we don't have any pre-signed up conferees to speak on this bill, but I will ask, are there any proponent conferees in the committee meeting room or on WebEx? Hearing and seeing none. Do we have any neutral conferees either in the committee room or on WebEx? Hearing and seeing none, I'll ask for opponent conferees either in the committee meeting room or on WebEx. Again, seeing and hearing none, I will direct the committee. We have proponent conferee written testimony in your committee documents from Ed Klump, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers Association. And we have opponent conferee written testimony in your committee documents from Jennifer Roth, Kansas Association of Criminal Defense Lawyers. Are there any questions from the committee members? Yes, Senator Thompson.
Yes, Madam Chairman. Actually, I would, as an attorney, I would like your opinion on the opponent testimony stating that Senate Bill 6 is likely unconstitutional regarding the fact that anything that enhances the severity of a punishment for a crime must be proven to a jury beyond a reasonable doubt. I don't know if you've had a chance to review that, but I'm curious if we're going to be doing something that is going to be reversed on appeal in a court somewhere.
Thank you, Senator Thompson. I appreciate the question. I'll ask Mr. Revisor, Mr. Thompson, do you have any insight on that statement that's been put forth by the conferee?
Thank you again, Madam Chair. This is Jason Thompson again. Had I realized there weren't any actual conferees testifying, I would have maybe said a little more earlier. So I'll start with this question. I looked in the House testimony on this same bill that was presented already this year, and I did not see an opponent testimony. So this is the first time I've seen it. But Ms. Roth is representing the criminal defense lawyers, and many of you know her as I do. Her argument is pretty sound that Apprendi, the case cited, does require proof before the trier of fact beyond a reasonable doubt of certain things so they can be used to enhance your sentence. To make the other argument, so to speak, the DV tag statute 22-4616 does require the trier of fact to determine whether the defendant committed a domestic violence offense. So I could see an argument that the current statute does require the trier of fact to make a finding, and so it could be used to enhance. I can also see Ms. Roth's argument that that is not sufficient under Apprendi. So I think we're going to have some good lawyers that may need to tell us that answer, which circles back a little bit to the history that I should have dug into a little bit more. That the bill did pass the House unanimously last year, and the Joint Committee on Corrections and Juvenile Justice Oversight that Vice Chairman Wilborn is on did recommend this bill for pre-filing. And so this is a new issue to me, and we may need to have a little discussion to make sure we have a constitutionally sound bill, but as of last year, we thought we did.
Thank you, man. Yeah, actually, that helps. I think this is something we better look into before we move this forward, so we make sure we're doing it correctly. That's just my opinion. Thank you, Madam Chair.
Thank you. I think that would be a sound way to proceed, to look into the argument raised in the opponent conferee written testimony before we would further work the bill. Does that present any other questions from committee? Seeing none, thank you, Mr. Thompson. And committee, then we will close the hearing on Senate Bill 6. And then we don't have any other bills that we're going to work today. So with that, we will be adjourned. Thank you.